to hearing what they have to share on this topic.
Thank you, Wes. Yes, so my name is Andrew Boyle. I'm one of the co-chairs, along with Atta Hindi, of the International Criminal Law Interest Group at ASIL. Just delighted to have the panelists that we have to speak about this issue today. Before I introduce the topic and our speakers, I do want to note and pay tribute to the late Justice Ginsburg, who passed and who was such a tremendous pathbreaker and an inspiration, particularly in regards to equality for women, but also, as I actually have come to learn only recently, was a big proponent of looking to international law to inform and learn from in terms of US domestic law. And so we certainly mourn her passing. The US has had a complex history with the International Criminal Court, starting with the negotiations around setting it up. But lately in the Trump administration, that history has taken on a more antagonistic tone, and then has recently, in the last few months, taken the form of the establishment of a sanctions regime, and then just earlier this month, the actual sanctioning of two individuals who work at the International Criminal Court in the Office of the Prosecutor, Fatou Bensouda, the prosecutor herself, and Fakiso Mochichoko, the head of the prosecution's Jurisdiction, Complementarity, and Cooperation Division. And so in order to discuss the context and the impact of these sanctions, we have brought together just a panel that I couldn't be more excited about. I also want to mention that we have, that you can submit questions during this webinar, and we will get to some of those questions later on. So getting to our panelists, I've necessarily had to cut down all of their bios because they've all done so many tremendous things. But our first panelist is Catherine Gallagher. She is a senior staff attorney at the Center for Constitutional Rights. She litigates civil actions in US federal courts under the US Constitution and Alien Tort Statute, including cases involving private military corporations and torture at Abu Ghraib, as well as universal jurisdiction and international criminal law cases involving US and foreign officials for torture and other serious human rights violations. Her major cases include the situation of Afghanistan at the International Criminal Court, pressing to open a criminal investigation of US torture in Afghanistan and at CIA black sites, Al-Shamari v. Kachi, brought by Iraqis detained, tortured at tortured at Abu Ghraib, and the Survivors Network of those abused by priests versus the Vatican, seeking accountability for the crimes against humanity of sexual violence by clergy and cover-up. Our next panelist is Liz Evanson. She is the Associate Director in the International Justice Program at Human Rights Watch. Her research and advocacy centers on the International Criminal Court, monitoring the court's institutional development and conducting advocacy towards officials and its member countries. Our next panelist is Adam Smith. He is an international trade partner in the Washington, D.C. office of Gibson, Dunn, and Crutcher. From 2010 to 2015, he served as the senior advisor to the director of the U.S. Treasury Department's Office of Foreign Assets Control, or OFAC, and as the director for multilateral affairs on the National Security Council. Adam is co-author with Richard Goldstone of the book International Judicial Institutions, The Architecture of International Justice at Home and Abroad by Routledge, and co-author of the book US, EU, and UN Sanctions by Bloomberg Publishing House. Our next panelist is Beth Van Schaack. She is the Leah Kaplan Visiting Professor in Human Rights at Stanford Law School and a faculty fellow with Stanford's Center for Human Rights and International Justice. She previously served as deputy to the Ambassador at Large for War Crimes Issues in the Office of Global Criminal Justice of the US Department of State under Secretaries Clinton and Kerry. She has also previously served as a professor at Santa Clara University School of Law and is acting executive director for the Center for Justice and Accountability. Her book, Imagining Justice for Syria, Water Always Finds Its Way, will be published, I believe, soon by Oxford University Press. And last but certainly not least, Kelly Zrobko is a pre-doctoral fellow and incoming assistant professor of government at the College of William and Mary. She's also founder and director of the International Justice Lab at William and Mary, and her research engages questions in human rights, transitional justice, and international law and courts. She has published analysis of US government policy and the US public on the International Criminal Court in International Studies Quarterly and the Washington Post. So thank you so much to all of you for joining us. Beth, I was wondering if I could ask you to start us off and talk about the evolution of the US's history and relationship with the International Criminal Court leading up to the Trump administration.
Sure, I'd be happy to. Good morning, good afternoon, everyone. It's really great to be here on such a terrific panel. So Andrew, as you mentioned, this is a policy and a relationship that has really been in a state of almost perpetual flux. Going back into sort of deep history of the field, the United States has always been actively involved in the project of international justice, really since the beginning. We had a very outsized role after World War II at Nuremberg and particularly in Tokyo. Everything sort of went quiet during the Cold War, as we know, but then during the renaissance of international criminal law in the mid-1990s, the United States was in a leadership position in terms of establishing new ad hoc tribunals for the former Yugoslavia, Rwanda, and then subsequently some hybrid tribunals for other situation countries. The United States was very engaged in negotiating the treaty that established the International Criminal Court, the Rome Statute. Once that launched sort of toward the end of the 1990s. And at the 1998 Rome Conference, which was charged with negotiating the final text and then opening it for signature, a number of red lines were crossed by the final draft. And so at the very end, the United States was not able to sort of join the large international consensus in support of that final treaty text. And there were a number of issues, but the three that are most relevant to the current situation are as follows. One, there was concern that the Security Council did not exercise enough, I think the word they would use is control over the work of the court. There was concern that the Office of the Prosecutor had the ability to initiate an investigation so long as the preconditions to jurisdiction were established on her own motion without any form of oversight. As it stands, we now have the requirement that the prosecutor go to a pretrial chamber. So that was a sort of response to the United States concerns, but I don't think it necessarily allayed those concerns entirely. And then finally was the jurisdictional concern that the court can exercise its criminal powers over the nationals of non-party states. In other words, if a national of the United States commits a crime on the territory of a state that has joined the treaty, that gives the court a form of territorial jurisdiction. And the United States has objected to that on the principle that it and its nationals can't be bound unless it joins the treaty. So in the waning days of the Clinton administration, President Clinton did ultimately sign the final text, really on one of the last days in which it was able to do so. But in doing so, he indicated that he did not necessarily recommend that the Senate consider it for ratification at that particular time. So that was the end of the Clinton administration. In the early days of the Bush administration, there was a concerted effort within the political branches to really cabin the risk to US persons posed by the court. And so this included the enactment of the American Service Members Protection Act, which created a number of barriers to the United States cooperating with the court, and also sort of imposed various negative repercussions on states that were in fact cooperating with the court, were joining the court, etc. They made a number of efforts to prevent allies and other states from joining the treaty, and they negotiated about 100 bilateral agreements, which are essentially non-surrender agreements. Basically, the parties pledged not to surrender each other's nationals to the International Criminal Court in the event that there's an investigation. Eventually, however, this stance really started to soften, and many of the most aggressive provisions within ASPA were ultimately declawed or were allowed to sort of expire. And the United States began to sort of shift, even under the Bush administration, towards a more normalized relationship. And by the end of the Bush administration, it had become clear that the court actually offered a useful institution to advance US interest in justice in certain circumstances, and particularly in those cases where there are atrocity crimes underway and there's really other no justice options. And so under those circumstances, the Bush administration allowed the Darfur referral to move forward. And as we know, that administration was very seized of the situation in Darfur, had declared it a genocide. Colin Powell had sort of arranged a very detailed and empirically strong investigation into refugees, et cetera, and had reached the point that in fact there was a genocide there. So this was the starting point for the Obama administration, which then developed, I think, a very constructive working relationship with the court, which involved the provision of a whole range of its assistance in virtually all of the investigations that were underway. This included information sharing, diplomatic support, conveying fugitives to the court, doing work within situation countries to advance justice there, encouraging cooperation, building peacekeeping mandates that included a justice element to it to help support the work of the court in those particular countries. And so by the end of the Obama administration, that's where things stood. It was a sort of working relationship. But of course, on the horizon was the Afghanistan investigation. And so I'll pause there because that's where things stood really when the Trump administration took office.
Thank you so much, Beth. Kelly, can I ask you to sort of pick up where Beth left off with, because the Afghanistan situation, there were a number of milestones that were hit under the Trump administration, and it seemed like there were some clear reactions to each of those milestones by the Trump administration.
Yeah, thank you so much. This is such a pleasure and a privilege to be a part of this panel, this discussion. Really excited to be here. Beth, thanks so much for so beautifully situating the U.S.'s current politics vis-a-vis the ICC, characterizing them as part of a broader history in international criminal justice, and more recently, about the last 20, 30 years, a growing withdrawal from international institutions, from international governance institutions. And so this isn't just about ICJ, but more generally about the US's relationship with international institutions. So in 2006, the Office of the Prosecutor at the ICC opened the preliminary examination into allegations of war crimes and crimes against humanity in the Afghan conflict since 2003, which is the year that Afghanistan became a member of the court. And so the task is to investigate allegations of abuses by both anti and pro-government forces, including the Taliban, the Afghan National Security Forces, the US Armed Forces, and the CIA. Over the course of its more than decade-long preliminary examination, so not quite yet an investigation at this point, an official investigation, OTP said that the information it gathered indicated, among other things, that US interrogation techniques used in Afghanistan, so involving torture, cruel treatment, outrages upon personal dignity, and rape, and this is from the preliminary examination reports issued by the Office of the Prosecutor, that these amounted to war crimes. Now, despite the US not being a member of the ICC, and to harken back to a point that Beth raised about jurisdiction over nationals of non-party states, the US personnel, military, and intelligence officials are subject to the court's jurisdiction because, again, the crimes in question happened on the territory of Afghanistan or in relation to the Afghan conflict, very importantly, including in black sites in Poland and other countries since 2003. And so in November 2017, after more than a decade of gathering evidence, Chief Prosecutor Fatou Bensouda requested authorization from the court's judges to open a full investigation. So moving from preliminary examination to full investigation, arguing again that there was a reasonable basis to believe that US military and intelligence personnel had committed these atrocity crimes. Now, it took about 1.5 years of consideration by the pretrial chamber judges. And in April 2019, they unanimously, which is quite interesting, rejected the request. They agreed that the issues in question were within the court's jurisdiction, and they agreed that it was admissible before the ICC. However, they claimed that the investigation would probably not be successful. So kind of like, why bother even trying? And therefore, it would not serve the interests of justice to proceed, which is, a rare use of this interests of victims argument, right? Interests of justice argument about whether or not to take on or to not take on an investigation. Now, this sparked controversy among ICC member states, among human rights advocates, including in international non-governmental organizations like Amnesty and Human Rights Watch, of course, and we have someone from there here as well. Organizations issued statements criticizing the court's judges for ostensibly capitulating to the Trump administration's threats, and in the process, effectively abandoning or sidelining the interests of victims. Now, one interesting protagonist who takes you from the Bush administration to the Trump administration is John Bolton, who was one of the fiercest opponents of the ICC, made these very impassioned speeches to different audiences about how the ICC would contravene US national interest and sovereignty, that would be unable to conduct foreign policy as we can and should, because of the threat of the hand of justice. And so effectively wanted to stay the hand of justice by having the US not be party to Rome, and to enter these non-surrender agreements with countries that receive military and other foreign aid, and then there were these threats of sanctions if the investigation proceeded. Now, Chief Prosecutor Bensouda, undeterred, as we have known her to be since her tenure began, swiftly appealed the decision starting in May and June, so just over a month after this decision. And they put together, her office, a multifaceted response, drawing on submissions from victims' legal representatives who said, actually, the victims would really like this to proceed, amicus curiae briefs from human rights organizations, et cetera. And so this past March, so 11 months later, the appeals chamber unanimously, again, reversed the pretrial chamber decision, saying that the pre-trial chamber had gone beyond its power. So this is some interesting intra-institutional, let's say kerfuffle or skirmish, but that's for a story for another day, for another analysis. But the pre-trial chamber judges had gone beyond their power by rejecting the prosecutor's request. Rome only requires that the pretrial chamber determine whether, and I quote from the statute, there is a reasonable basis to proceed with an investigation and whether the case appears to fall within the jurisdiction of the court, which again, the pretrial chamber had agreed to. These facts were not in dispute. And so Bensouda and her team were authorized to proceed, catalyzing the sanctions that came not exactly immediately, about 3 months later, or the sanctions threat rather, and now at the top of this month, the first pair of sanctions being levied against court personnel. And so I guess I'll just conclude by saying the trajectory of US behavior vis-a-vis the court, so aggression, détente, aggression, cooperation, et cetera, doesn't really correspond to trends in US public opinion that we observe. And so I was inspired a few years back by some polling research that was being done by Ipsos and the American Bar Association International Criminal Court Project, which found that Americans were learning more, so they knew more about the ICC over time, and that as their knowledge grew, so too did their support, which is something that I was quite curious about, because sometimes we infer public opinion from government policy, but as political scientists like myself and others will show in our work, that there is not always this neat correspondence. And so I was kind of curious about what types of knowledge shaped what types of opinion. And so I did some experiments now published in the International Studies Quarterly about different arguments for and against ICC membership, specifically human rights arguments and national interest arguments. At a baseline, Americans support the ICC, even given possibility of investigation. And that as you introduce human rights arguments, they become even more supportive. They become slightly less supportive when national interest arguments are deployed, but there's kind of a moderating effect when you introduce both sets of arguments. So this really means, I think, that we can advance towards a more substantive conversation about complementarity and justice within the United States. And so the moves by the Trump administration may be misguided, and as I've written in the post, may trigger a sort of Streisand effect, where because Trump does not like it and Trump is losing support from all corners, this may actually become something the US public supports even more. Something I'm investigating with colleagues now is public opinion, basically American support for war crimes prosecutions, now that we don't have a hypothetical, now that there's investigation actually ongoing. And so perhaps in the ideal, we said, yes, criminal justice, but maybe once the actual, scepter, or the specter, excuse me, of international criminal justice is here, that perhaps the tune changes. Thanks.
Thank you so much, Kelly. That's really helpful. Kelly mentioned, Katie, that about the interests of the Afghan victims in this case, and I know that you have been involved in the case, in the investigation representing victims, and I was hoping that you could give us a perspective from within the case of the evolution of the investigation and the reactions of the Trump administration.
Sure. Well, thank you. And thank you for including me in this panel. I've already learned, and Kelly, I'm going to follow up on the research that you're doing. And I also want to thank the audience for being with us today. This is such a challenging time for so many, and to come and listen to a topic that may seem far away, I really appreciate you taking the time. So I'm an attorney at the Center for Constitutional Rights in New York, and CCR for many years has represented, primarily in US courts, a variety of victims of post 9/11 executive or political branch abuses, including individuals who were picked up in the so-called war on terror and detained around the world, including at Guantanamo. So that is kind of the entree point to why and how we are involved in proceedings at the International Criminal Court. I am not someone who represents individuals in Guantanamo in US courts, but with a background in international criminal law, I have picked up the accountability work for the last 14 years, looking for fora outside the United States, because our initial efforts at accountability in US courts, be it civil cases or efforts to try and get criminal investigations open, all largely came to naught. And I think that this is important to remind ourselves. As Kelly mentioned, complementarity is sort of the system on which the ICC is built. It very much is the system upon which the ICC is built. So it is a court of last resort, and it is a place where you go if the home country of the perpetrators is unwilling or unable to investigate. And unfortunately, when it comes to allegations of US torture, that is the case. So I want to be also quite clear, there are many, many victims in the situation of Afghanistan. And on this panel, we are not talking about the vast majority of the victims, which are themselves Afghan victims. Afghanistan chose to join the ICC. Afghanistan put its territory before the International Criminal Court, and Afghanistan put its trust in the ICC as being a forum for justice and accountability, including and primarily for its citizens. And the political situation that we find ourselves in vis-a-vis the situation of Afghanistan. It's important to remember at this point it is blocking justice for victims in Afghanistan. I represent victims in what I call the third dimension of the situation of Afghanistan, and that's US crimes. So I represent Ghali Duran and Charkawi El-Haj. These are two individuals who remain detained at Guantanamo today. Both individuals at one point or another had been held in Afghanistan, having been transported through different detention sites, including on the territory of other ICC member states, including Jordan. At one point, one was in Djibouti as well. So that is why and how these victims are victims before the ICC. They were subject to crimes within the jurisdiction of the court, war crimes, and I would submit crimes against humanity that occurred on the territory of multiple ICC member states. The ICC is unique in the International Criminal Tribunal world in that it allows for a more robust form of victim participation. It is a beauty of the statute. It was hard fought by victims' rights groups back in Rome. Another one of the many fights was robust participation of victims so that they were not simply objects of the proceedings, but were themselves subjects. So for many, many years, victims of all three dimensions, crimes by the Taliban, crimes by Afghan national forces, and crimes of US torture, all had been pushing for the preliminary examination to move to an investigation stage. And as Kelly mentioned, that preliminary examination went on for many years, more than a decade. So this is a long case of justice delayed. We hope it will not end in justice denied. So victims already were participating and pushing for this request to open an investigation. And then once that request was filed, victims are allowed to file what are called victim participation forms. In my case, empowered by the two individuals at Guantanamo, I filed the official form of the registry as well as a 55-page substantive brief laying out our view of what the investigation should entail. So victims are allowed to opine on the scope of the investigation. We were providing facts. Keep in mind that we've been seeking accountability already for more than a decade by the time this investigation request goes forward. So whether it was providing leads, investigative leads, compiling information that's in the public domain, including by US government investigations, by the military, by Congress. There's a lot of information out there. Synthesizing that and sending it on to the prosecution. In our case, we did argue for crimes against humanity. We also argued why it is that so many ICC member states, keep in mind there are 123 ICC member states, the majority of the world, they are part of this international justice system. Unfortunately, many of those countries had participated in one way or another with the US torture program, be it hosting black sites, as was mentioned by Poland, Romania, and Lithuania and Afghanistan, whether it was rendition flights that landed and refueled on territory or flew over. So we also pointed out to the prosecution the many countries that should have information to assist this investigation. Member states are obligated to respond to investigation requests. So all of this went into our victim participation form, and most notably, as Kelly mentioned, the interest of justice. This is a question that is asked by the victims. And in our case, we urged the pretrial chamber to open the investigation without any further delay. And the request to open the investigation did come at a time while Donald Trump was president. And at that point already, we were hearing him say, maybe we need to return to torture. I can bring back waterboarding and a hell of a lot worse. So we warned about the fact that without accountability, you can have reoccurrence. And that is, again, part of the core principles enshrined in the Rome Statute. The goal is to prevent and redress egregious crimes. Over the course of the time that the request to open an investigation was pending, we also made subsequent filings to both the pretrial chamber and to the prosecution. We noted the fact that Gina Haspel, who had run a black site during the Bush years, was named as CIA director. So this was something that, again, in our opinion, showed why accountability was necessary. And we also pointed out the declining health of one of our Guantanamo detainees. So we really urged the court to move quickly. Of course, as Kelly mentioned, in the background was a steady drumbeat from Trump administration officials and John Bolton before he was in the administration, and then once he was in the administration, threatening already sanctions and punishment for the ICC if it moved forward with the investigation. And as we know, the pretrial chamber originally declined to open the investigation, citing, the relevant political landscape. As victims reps, we filed an appeal, and I will briefly mention that, but we also went to the UN Special Rapporteur on the independence of judges and lawyers and pointed out already the pressure that was being placed on an independent court, a prosecutor and judges by the Trump administration to interfere improperly with the course of justice. So I think that is the frame that I would say is the appropriate one to look at this. It's an interference with the independence of the judiciary and the prosecutor. This is about something, a larger principle than just the ICC. We also filed a notice of appeal as victims, and there were novel issues that were raised over the course of the appeal briefing about the role of victims in initiating appeals and how robust our engagement and involvement could be. We did substantive briefing on all of the issues, including on whether or not the interest of justice is something for the pretrial chamber to look at on its own, and advance the argument that the appeals chamber ultimately adopted. In the appeal, not only were we active participants in the briefing and at the 3-day hearing, so were amici. And those amici, both in support, the vast majority in support of opening the investigation. Jay Sekulow, Donald Trump's personal lawyer through his European-based NGO, was also present at the argument and argued against opening the investigation. But as I said, the vast majority were in support. And that included former US officials, that included academics, that included former prosecutors, that included victims representatives, former UN special rapporteurs. So I think it's just important to bear in mind the many people who participate in the course of justice who may be brought under the umbrella once we get into talking about sanctions. The final point I would mention is that the investigation, while authorized, at this point appears to be on hold. Soon after the authorization, Secretary of State Pompeo flew to Kabul, and the day after that trip, Afghanistan announced that it was seeking a deferral of the investigation. We have yet to see that actual filing. We know that it went in June, and I would argue that whatever legitimacy there may be for Afghanistan to look at its crimes committed by Afghans, it is not an argument that should block the investigation of the US dimension of this, because the US has been unwilling and unable, well, unwilling, certainly able, to investigate US torture. So for us as victims representatives, it's a very distressing journey to justice. And again, it's one that is very much delayed. I'll stop there.
Thank you so much for that, Katie. Liz, you are sort of constantly in touch with the NGO community and governments regarding the International Criminal Court. Can you give us a sense of what the sort of perspective of was of these organizations, these states, many of whom are parties to the Rome Statute, regarding the Trump administration leading up to these sanctions, and also, where these sanctions come, which Adam is going to tell us about next, but where they come, sort of where the court is at this moment, there are some elections coming up and things like that would be helpful to sort of situate us.
Great. Thanks, Andrew. And I just also want to add my thanks to you and to Aisel and colleagues for convening us all here for this really important discussion. And I'm just glad to be part of it. So let me just talk a little bit about some of what we've seen over the last 2 years when it comes to ICC member countries and civil society responses as the US government has escalated its attack on the ICC. It was, just a little over 2 years ago that the then National Security Advisor John Bolton announced this new approach to the court, stopping cooperation and unrolling a menu of retaliatory measures that the US government said it would be prepared to take if the ICC went forward with certain investigations, particularly the Afghanistan investigation. And that then escalated up towards the next year. We saw the imposition of a policy of visa restrictions and the revocation of the ICC prosecutor's visa, and then in June the executive order putting in place a sanctions regime, which we'll get onto next. And over the course of up until June, so nearly 2 years, we have seen ICC member countries, we have seen civil society try to come forward and match this escalated effort with responses that make evident the strong support that exists for the ICC, and to offer a counter narrative to any sense that what the court is doing is in any way illegitimate. To the contrary, that actually the court is carrying out the mandate that was given to it by the international community and consistent with the international treaty that governs its work. And I just want to say how important and necessary this work is. There's always so much more that we would like to see from ICC member countries, but it is absolutely essential. I mean, the International Criminal Court has a very difficult job. It has to depend on governments for support, for cooperation in investigations, for cooperation in arrests. And at some level, that all comes back to there also needing to be a strong political consensus about the importance of accountability, and a political consensus around the norm that as an international community, we are no longer going to tolerate these worst of the worst crimes being committed with impunity. And every time the ICC acts in a new situation, that political consensus has to be built and rebuilt again. And I just don't think we can take it for granted. And it's also a lesson that's been learned even prior to the Trump administration's change of approach 2 years ago from previous times when the court has faced in its 17 years or so that it's been operating politicized opposition. We've seen how ICC member countries working together was necessary when it came to resisting calls for mass withdrawal from the court's treaty from some on the African continent, again, pressed by civil society, pressed by NGOs to show support for the court. And of course, we saw that when, as Beth laid out, there was a real hostility towards the court in its earliest years from the US government at that time. So we know the court needs political support to do its work. And I think the last 2 years have been trying to, again, kind of manifest that support, really with the aim, as Katie said, of making sure that the court has the space to do its work. I mean, that's really what this boils down to. It's making sure that the court has the space to take decisions with independence, whether we're talking about the judges or the prosecutor. And these tactics by the US government have been about trying to put the institution under so much pressure that independence is called into question. And it's particularly when its independence or its legitimacy are being called into question that we need to hear these messages of support from ICC member countries. So more concretely, what we've seen, again, if we look back to 2 years ago, it was just around this time as we have this week, the general debate, the high-level week at the UN General Assembly. And that was only a couple of weeks after Bolton's first announcement of this new approach. And we saw there, a record number of ICC member countries referring to their support for the ICC in those statements. So at the very highest levels of government, it was sort of almost an immediate reaction to what Bolton was saying, and even to what President Trump said at the General Assembly that year. And we also saw the first of now what are 3 joint statements that have been issued by ICC member countries on a cross-regional basis. The number has grown and changed, and we'll talk about what's happened since the executive order. But I mentioned that those statements, not because they're the only tool or the most important, but I think their quality is very reflective of the ICC project, because we're talking about statements where 30 or 40 ICC member countries, but from different regions of the world, come together to express their support for the court and to really show that this is an institution that has that global level of support and is considered by many countries to be part of their own national justice systems. We also saw at the annual meeting of ICC member countries, they meet once a year to take decisions about the court's budget, to talk about cooperation, to elect officials. So in 2018, we saw states parties adopt language in their general resolution for that meeting, again, affirming their support for the court and their determination to remain undeterred by threats. And that language was then readopted at last year's meeting. And we also saw, once the visa restrictions were announced in 2019, statements by the president of the ICC's Assembly of States Parties, by the EU, by national governments, again, expressing concern that these threats to the court were going to the core of its independence and putting inappropriate pressure on the court. And we've seen those efforts again continue. And this year, in the couple of months before the June executive order, the US government was making it very clear that it was intending to take further steps against the court. The idea of economic sanctions had been there from the beginning in John Bolton's menu, mentioned by the Secretary of State. And in March, after the appeals chamber authorized the Afghanistan decision, the Secretary of State had called out to ICC staff members by name, had signaled that the US was looking to take further measures. And again, you saw this kind of a new joint statement by states parties, individual statements by the Assembly of States Parties president. So we can talk about how these responses have kind of consolidated and continued since the executive order, but that's sort of been the trend. And again, it's been echoed and mirrored in civil society, both globally. In the spring, we were part of a letter by a number of NGOs working globally and locally to call on their own governments as ICC member countries to make sure that they stood up for the court. There have also been initiatives among US-based civil society, a joint letter that was sent in March to the Secretary of State as these threats were kind of coming more and more to the fore, reminding the Secretary that there has been a constituency of support for the court among US-based organizations that understand its value as a court of last resort. And we also saw some very important, very influential voices. I think civil society is not quite the right term for it, but we saw joint statements by international prosecutors, US persons who have served as international prosecutors, as well as the former war crimes ambassadors, also issue a joint statement of concern about threats to the court. So we've seen, again, kind of parallel efforts to try to mount a strong and clear message of support for the ICC as an essential court of last resort as these steps have escalated by the US government. It's always important, that's where I began. This court needs this kind of public and private diplomacy by state parties. It needs public support. And I am so interested in Kelly's research about US public opinion on the court and what could be done to spread more information about that. I just wanted to conclude these remarks by saying it's all the more important right now because, as you said, Andrew, the court is really at a very critical juncture. It's no surprise that it's attracting this kind of politicized opposition because with the Afghanistan investigation, with other investigations that's opened recently on Myanmar, on Georgia, it's really showing the potential for the aspiration that brought many NGOs, brought many like-minded governments together at its creation, which was a court that would show that there is equality before the law, that these kinds of abuses won't be tolerated provided they fall within the court's jurisdiction. Of course, that's going to be unpopular, There's also a pending decision as to whether the prosecutor can go ahead with an investigation in the situation of Palestine. So it's on the verge of really demonstrating, I think, what brought so many together in Rome 22 years ago. And at the same time, it has suffered from real disappointments in how it's performed as a court. I think its existence exerts a very strong normative force and has had a real knock-on effect on other accountability processes and measures, but it has disappointed expectations for the justice that it delivers. And there's a very serious effort underway to address that through a panel of experts that states parties commissioned last year. That report's coming out next week. There's also the absolutely critical election of the next prosecutor. The prosecutor at the ICC serves a term of 9 years, so has tremendous importance in terms of leadership of the institution. And for me, it's really a concern that election takes place with the full understanding that what states parties want is a prosecutor that will really pursue the mandate of the court to the hilt in full independence. So all of these different dynamics are kind of coming together, and the US administration's attack on the court is really coming at this very critical juncture for the court itself.
Thank you so much, Liz. Adam, I know you've, in your role at the Treasury Department, you were involved in setting up sanctions regimes against various entities. Obviously, you know this law like few do. And I believe you have a presentation to sort of aid us in understanding exactly how this law works and how it's being applied here.
Absolutely. And again, thank you very much for having me. I find sanctions both fairly self-explanatory and also fairly complicated at the same time. And so I took the liberty of putting a couple of slides together just to go through what it is we're talking about when we talk about sanctions and how it's been working. Andrew, let me know if this doesn't work. I'm doing my sharing of the screen. And does everyone see the, yep, you see it, Andrew?
Yeah, I can see, yeah, I can see it. It looks great. Okay.
So very briefly, when we talk about sanctions, and do you see the whole thing or just the slide itself? You see just the slide?
I see the slide and then the next slide, but I think it.
No worries.
Yeah.
No worries. I think we can, hold on. Apologies.
No problem.
There. How about that?
Yep.
Does that work?
Okay. I just see the slide. Yeah.
Perfect. Okay. So sanctions in general, as I'm sure many of you know, used to be very much unused. And then by this year, frankly, by about 10 years ago, it became the tool of choice for almost every single foreign policy issue that you might imagine. When I was in the government, both the Treasury and the White House, it's not an exaggeration to say that a week or 2 weeks would not go past without someone raising the idea of sanctions to address some issue. So it really became a very aggressive tool set. This gives you a sense of what we're talking about. The number of sanctions programs has increased 300%. This is even outside the context of the ICC. The number of individuals who are sanctioned on what's called the specially designated national list, the SDN list, has gone up by 50%, actually closer to 60 or 70%. The number of changes to this SDN list, people who are being added and subtracted. Just this morning, to give you an example, 35 entities, individuals were added. I mean, it's literally every day there are more individuals, entities added for a whole host of different reasons. And to give you a sense of the global impact here, this map demonstrates sort of the global reality of people who are sanctioned, people and entities. It's a global issue. And the ICC is just the latest of the sanctions programs that are in place. There are about 60 odd sanctions programs now for which entities can be sanctioned around the world. And even though you might think of Iran or narcotics traffickers or Russia or what have you as really the places where most sanctions are, it's true to a point, but it's also true that in 168 jurisdictions, there are people who are sanctioned, companies, individuals, et cetera. So it's a global issue in a way that frankly few are. The reason this works from the US perspective as a legal matter is because of something called the executive order, which I'm sure many of you on the call are well aware of. An executive order, which is how the US imposes sanctions, which makes it different than how other jurisdictions impose sanctions in some respects. It's basically, it's an order from the president, the executive, directing elements of his administration, the executive, basically to write regulations, directing them to impose law that already exists. And so what that means is that under sanctions, the relevant piece of legislation has been around for 40 plus years now. It's this International Emergency Economic Powers Act from 1977. And the way this works, the reason it can happen so quickly and so aggressively is because of the way our system works, right? You have our Constitution, of course, you have laws, but then you have regulations, which are actually how they're implemented. And the way the executive orders work is they are directive to the Treasury Department, where I used to work, and other departments sometimes, to write regulations to impose sanctions. Because what IEPA allows you to do, which I'll go into in a moment, is impose these really quite extreme measures to control property interests on behalf of parties who are sanctioned. And of course, this president loves his executive orders, not just sanctions based, but in general, it seems to be a tool for him that he really enjoys, which we can talk about without getting political. We can talk about it if you'd like. So how do they work? So an executive order looks like this. It's an executive order. This is the ICC executive order that came out in June of 2020. Most executive orders sort of look the same. There are different components here that you can sort of read through and figure out what's actually happening. So the first and most important piece, of course, is the authorizing legislation. This is IEPA, the one I just mentioned. This allows the president to basically do almost anything with respect to property associated with parties that are listed. And we'll talk about how that works. So that's the legal basis. You then have the policy basis, and I'm not going to go through it, but it's basically everything that the prior folks on this call mentioned. Everything to do with what the U.S. is not being a party, talking about the American Service Members Protection Act. ICC is a problem, and ICC is a national security threat. That's basically what the president is saying here. And then you have what's called the legal trigger, right? So what the president needs to do under IEPA is he needs to basically come up with this phraseology. Whatever the policy basis is, he needs to define it as a, quote, unusual and extraordinary threat to national security and foreign policy of the United States. And I'm going to declare a national emergency to deal with that threat. There is no definition for any of those terms. Unusual, extraordinary, national emergency, none of it. And so the reality is the president has incredible flexibility, which is why this president and others likes this tool so much, to identify anything in the world he or she would identify as being an emergency as such, with very limited oversight. In fact, almost no oversight. He has to notify Congress, and that's it. Notify, not get authorization. So then the executive order moves on and talks about targeting. Okay, so that's the authority in place. Who is going to be targeted? And that's what you get to next. Any foreign person determined by the Secretary of State for engaging in these sorts of activities, right? Directly engaged in an effort by the ICC to investigate, the US persons to investigate or detain someone who's an ally of the US, or to have materially assisted anybody in those two categories. Or a status, right? To be owned or controlled or acted before on behalf of parties. Now, to be sanctioned, the evidence needed is incredibly low, right? This is an administrative act, not a judicial act. And so the evidence you need is a reasonable basis to believe. The Administrative Procedures Act, basically standard. And so that's a very, very modest standard. And under this authority, possible targets could include individuals, companies, organizations, parts of entities. It's really anything. OFAC, the agency of Treasury that deals with this, has sanctioned everybody from heads of states to soccer teams to company directors to NGOs and everything everything above. It's really quite an amazing broad breadth of who can be targeted. And then what is the consequence, right? The consequence of being sanctioned. And this is the other piece. IEPA is very broad. There's a lot of things the president could do, but traditionally he uses this tool to do this. He says, all property, interest in property in the United States that are in the United States as a stock matter or that come into the United States are blocked, right? Are frozen. The definition of property, interest in property, and even US person are very, very broad, which we could talk about. It's why it's relevant that a prosecutor who is Gambian and lives in The Hague, why this is relevant to her, and of course her deputy. They were designated December 2nd, 2020. So what does that mean for them, right? As a practical matter, this executive order is now in force, right? It's now not what's called a naked executive order. They're actually people that are designated. So two things now happen to these two targets. So they've eliminated all access to the US as an economic matter. right? Any property they may have in the United States or under US jurisdiction, including at US banks abroad, are frozen, right? They cannot access them. They still own them as a property matter, but they cannot access them, right? All financial, commercial, consumer markets. This is a big, big loss, principally for companies. You might think, okay, well, these people are legal professionals. They're not companies. They don't have, I'm guessing, huge amounts of assets in the United States, and that's true. The other thing that it eliminates is all US dollar transactions in which they may be involved, right? Why is that relevant? That's relevant because the vast majority of international trade is done in US dollars. So if you're buying a plane ticket in The Hague to go to name your country of choice, that may well be priced in dollars. And if a transaction like that is priced in dollars, the likelihood is that it has a US touch point. Because when you do a US dollar trade, even with countries that don't have a US touch point, the dollar itself has a touch point. So if you're trading between the Netherlands and you're trying to fly to the Gambia, right, to go home, you're going from the Gambian currency to the euro. And the reality is that if you're using dollars, that transaction actually it goes from Amsterdam to Banjul, but it actually goes via New York, right, to dollarize that transaction. Any transaction in which they're involved, it becomes off limits. It's a huge, huge problem. Again, principally for companies more than individuals, but the reality is because of this risk, it's not so much that Bensouda will get into trouble for trying to do this. It's that the banks and intermediaries on whom she relies to do her professional work and her personal life will be impacted and may well shy away from engaging with her. So it's a real imposition, not just on the court as her being the prosecutor, but her as a person, right? Because you are sanctioned in all capacities of your life, professional and personal, even just for the professional activities. And so one last slide to tell you sort of about the risks and how people sort of view this is that there are 3 levels of risks about what people are thinking about when dealing with Bensouda or her deputy. One is enforcement, right? So if you're a US person, a US company, US NGO, a US academic, you could be enforced against for providing services or otherwise to Bensouda or Motochoko. That enforcement requires a US touch point, so that it's only for US persons. But that could be a serious issue. The possible outcome there is civil and criminal consequences, right? The IEPA statute I've mentioned is a criminal statute at its base. So that's a very serious issue. It happens about 30 times a year that there's enforcement, more or less. Second concern under the executive order is designation, right? Designation is being added to the SDN list and therefore having the same consequences that are now in place against Bensouda and Motochoko. OFAC merely needs to have a reasonable basis to believe that a person's or an entity's activities is covered by the executive order. As I've said, incredibly broad, right? Incredibly broad, incredibly flexible. And of course, the consequences there are quite substantial, right? The people in Colombia who have been sanctioned in the narcotics context call being sanctioned muerte civil, civil death, right? Because banks and everyone shy away from dealing with you because of the concern about falling afoul of US regulations. Because if you're a bank, you're really concerned about losing access to the US dollar, because that's, again, so much trade is done in that way. And so that's the concern. It's a knock-on effect that people are concerned about. And that, of course, designations happen a lot, hundreds, if not more per year. This administration has been very active adding people to the list. The third area of risk, that this actually is what I'm even most concerned about, are these reputational or commercial consequences. This is actually people who are not actually afraid of being enforced against because they are not US persons, let's say, and they think the likelihood of designation seems low, but are nonetheless shying away from engaging with parties who are on the list because of the fear of the knock-on effect of the banks or otherwise basically looking at them and saying, I don't want to deal with you anymore. At its most extreme, it would be something as benign as renting a house to someone who is an SDN, right? So if you're going to do that, you can do that. There's nothing illegal about that. But are you going to find a bank or an insurance agent or some other intermediary that's willing to put themselves at risk when they see an SDN on that transaction chain? That's the risk here. So it's an unbelievably broad authority that, truth be told, has never, ever been used, as far as I'm aware, certainly against international prosecutors. But the traditional person on these lists and company on those are pretty bad actors, right? Not just people who are doing things the US doesn't really like, but rather are narcotics traffickers, are terrorists, are WMD proliferators, people who, cyber terrorists who sort of, interfere in our elections. This is the kind of typical character on the SDN list, that specially designated blacklist. So it's very odd, but as a purely legal matter, we could talk about challenges and all the rest. As I read it, the IEPA and how it's used, it seems to be in the bounds of a justifiable reading of IEPA to do this, right? So in other words, it's a policy call that the law appears to, at least in some respects, support. We can question that in some ways, but the jurisprudence on this is not very positive with respect to people challenging the executive's authority to claim a national security emergency and impose sanctions thereunder. It doesn't mean it's not challengeable. It just means that there is a challenge in doing so because it happens very rarely and often unsuccessfully. I think that is it. I'm going to stop sharing my screen. There we go.
Much, Adam. Yeah, that worked. Yeah, and that was incredibly helpful to understanding it. I want to turn to you for a couple of reactions. First, let me lay out some of the points that I've heard the Trump administration make in regards to why they're imposing these sanctions. I've heard folks from the administration make a claim that if U.S. persons were brought before the International Criminal Court, that the court does not live up to the due process standards that U.S. persons are entitled to in the United States. That's problematic. That, of course, that the United States is not a party to the Rome Statute, and so there's no reason for Americans to be before that court. Obviously, there's the argument that this is being done to protect U.S. troops and U.S. Personnel, and then there are arguments about that the court itself is dysfunctional and shouldn't be allowed to reach out and bring Americans before it. So I'd be interested in and I know that those are arguments that you have heard before, and in hearing your reactions to those. And then as a second question, sort of as a hypothetical, I'd be interested to know, if you were the Secretary of State or if you were the president, and you nevertheless disagreed with the International Criminal Court's actions in regards to Afghanistan, or you disagreed that America should be there. Was there a better way to go about this? Is there a better way to both engage with the court and say, however, we disagree strenuously on some of these actions that you're taking?
Yeah, thank you. There's a lot there, so I'll try and hit on everything. There's no question that this is an extremely fraught issue, and any administration, and even at the end of the Obama administration, I think some of the cooperation efforts were starting to become a little more difficult as we saw this Afghanistan investigation moving forward. I think it's important to note that the risk of a U.S. person coming before the court, I think, is still very low. It's not zero, and I think there are many within the U.S. government that would only be satisfied with zero. But as Katie mentioned, this is an enormous crime base. There are thousands of victims that have been subjected to war and crimes against humanity for decades at this point. And so, putting the US issue to the side, there are many crimes that are literally crying out for justice. And so, what is the risk of a US person actually coming forward? It's not zero. And so we have to address this issue. And Steve Coe in the Q&A asked a really great question, which is sort of what would a Hillary Rodham Clinton administration have done? And I think we can ask the question of what would, if things come to pass, a Biden administration do. And there's no question that there's going to be a lot of interagency tension around coming up with an appropriate response by the US government that, on the one hand, advances the larger justice goals of the International Criminal Court, works, as Liz discussed, on this reform/review process to try and build a court that's actually functional, that actually lives up to the expectations of victims, that actually does what we envisioned it would do in the situation countries that so cry out for it because there's no other justice options available. And so how do we maintain and be a constructive player on this side while also robustly defending against the exercise of jurisdiction over a US person if that would happen to come to pass. And walking that line, and as Jane Stromseth has said in remarks, sort of walking and chewing gum at the same time is always tricky. And so I would hope that we would be willing to defend against this action within the context of the rule of law. And that would include within the Rome Statute system. Now, many will argue, listen, we're not members, we have no cooperation obligations, we haven't even accepted the notion of complementarity, we haven't accepted the right of the court to scrutinize our how we chose as a nation to address the horrible crimes committed during, in custodial abuses that happened during the so-called war on terror. And so there will be some that will argue that we shouldn't, quote unquote, legitimize the institution by participating in processes in a formal matter where we would submit briefing, for example, submit data that shows that there were disciplinary proceedings taken, submit information that argues that the court's test of complementarity is actually the wrong one, that they should be looking more broadly in a more holistic or gestalt sense at how the society responded by legal reform, by putting in place measures of non-repetition, by engaging in a searching commission of inquiry to determine where things went wrong and how to ensure that that doesn't happen again. We can work within the system while also defending rigorously. So I think getting that balance right is going to be a challenge to any administration, given the interagency tensions at issue, because of course the Pentagon has its issues, and then there's the Central Intelligence Agency. I think it's important to keep those two entities separate because there were disciplinary proceedings within the Pentagon, as we know. And so the question is that enough? I think there are strong complementarity arguments that can be made with respect to some incidents, but that didn't go up the chain of command, as we know, and there hasn't been real accountability at all when it comes to the so-called black sites that Katie mentioned, which were the really virulent manifestations of the global war on terror. And so, we have certain arguments that we can deploy, and we should deploy those to the greatest extent possible, but whether or not those would be convincing is another question. There's also this issue of the objection to the assertion of jurisdiction over US persons as nationals of a non-party state. And that argument gets made. It's not clear how convincing it is and whether it has any real legal basis. And so then the question is, are you willing to advance additional arguments, or are you simply going to stop at this as a sort of threshold argument? And if you've ever been a practicing lawyer, you know that you want to deploy whatever arguments you have, because you have different constituencies that might find different arguments appealing and convincing and be willing to rule in your favor. And so I would encourage a new administration, and even this administration, if it has a second term, to think strongly about, fine, make your points on whether jurisdiction exists, but be prepared to argue on the merits as to why you think this matter should not move forward vis-a-vis US persons. You asked about the due process question, and of course, US persons are subject to whatever the criminal procedure systems are around the world if they commit a crime on the territory. So a US person committing a crime on Afghanistan, putting aside any sofas that might apply, would be subject to whatever the Afghan national system would apply. So the fact that there's no jury trial, for example, at the ICC is one of the big objections. There's many states of the world that don't offer criminal defendants jury trials, and US persons are regularly prosecuted before those systems. So that to me is not a strong argument necessarily for why the ICC should not be allowed to assert jurisdiction over US persons. So I think, where some of my work and others have really tried to highlight is, obviously this sanctions they have a very strong signaling effect, right? This is our resolve. We are aggressively opposing the exercise of jurisdiction. But the real question, I think, is, and Liz got into this a lot in her remarks, is, are these ultimately going to be counterproductive in terms of alienating other allies who might be willing to help us advance these other defensive arguments that might be available to us? And I think the reality is, this is so beyond the pale that it's going to be really difficult to find states that are willing to, including members of the assemblies of states parties, that might be able to think about rules changes or signaling effects as to how complementarity should work, how gravity should work, how the court should approach non-party states with maybe a higher degree of deference, et cetera. We don't have allies that are willing to necessarily help us with these arguments because we've so alienated everyone with this extremely aggressive approach.
Thank you. And you mentioned one of the questions I had. We do have a number of questions that I'm going to try to incorporate in the time that we have left. But Kelly, I was wondering if I could ask you, as our resident international relations scholar, how do these actions, do you think, affect U.S. relations with our allies and perhaps even with our enemies? And do you have suggestions based off of the research that you've done about how the International Criminal Court could respond in a way that speaks to the U.S. public in a way that might be more effective than trying to deal directly with the Trump administration?
Thank you. These are terrific questions. And can I just say that I've really been enjoying everyone's interventions. I'm learning a lot. That sanctions slide deck was phenomenal, Adam. Thanks for that. I learned a ton. So in terms of our relations with allies, they have tolerated U.S. engagement, disengagement, withdrawal from international institutions over several decades. And so in some respects, we might not expect much from them by way of sanctioning, not in the manner that we're discussing, but in terms of, criticizing the U.S. in substantive ways, that make an impact. We were, the U.S., as others have discussed before, had this really powerful role after World War II in Nuremberg and in Tokyo, and establishing hybrid tribunals and participating in Rome, but then ultimately not, and signing, but ultimately not ratifying. And so this is, 2 decades old now, right, in terms of this behavior. But what changes now, right, is the US's actions against the prosecutor. I think this is where, if our allies, let's say in the UK or in France or others, want to really underscore the legitimacy of the court and want to support its work and really to feed its existence, right? We're at a critical juncture, as Liz and others have discussed. This actually might be the thing to make them really come out forcefully against the US, maybe some types of diplomatic pressure, either to just back off and let the investigation proceed. Again, as Beth discussed, very low probability of US personnel ever, making their way to The Hague, in part because there are many, many victims and many, many perpetrators, many of whom are not American nationals. And so that's one thing. It's a little bit hard to speculate about just ally responses because our allies let us get away with a lot, in part because of the economic and military and diplomatic power we do have. And so there's a lot of kind of, turn the other cheek, including and perhaps especially on matters of international criminal justice. Also, to reiterate a point made earlier, some of these allies were touch spots in the extraordinary rendition flights. And so they might not, seek to opine, so forcefully or with such great passion because they were part of these engagements as well. And something that perhaps is a conversation for another day is what responses, political, judicial, or other, should be levied against those who participated or at least enabled, if not practicing themselves, these practices that Bensouda and others have argued amount to war crimes. So that's that, I guess, on the IR component. I'm sorry that that was perhaps not the most satisfying response. We don't know, time will tell. I can tell you with greater certainty though, about some ways in which the ICC might like to speak to everyday Americans, to the public. Now, so in my study, like I said, I just wanted to see what Americans thought about US membership. And so we have a control group, as we should always have an experiments. And then there was the people who received the human rights treatment. So, consistent with US promotion of democracy, human rights, et cetera, part of our post-war, advancement of international criminal justice, anti-impunity around the world, et cetera. National interest argument that, international organizations sometimes are biased against the US, and we're involved in so many situations abroad that there may be a case that is pursued for political reasons. And then, of course, the competing frames where people received both, and essentially in this group moderated their views, so kind of got to this middle point. Some other things that I explored in this set of experiments was alternative or other types of arguments that might appeal to Americans. And equally, if not more salient and effective, were arguments, or rather the idea of impartiality and effectiveness, right? So this wasn't something that I asked directly about the ICC, but really about people's views about international organizations and the UN in particular. And this was, in terms of a correlate of supporting US membership of the ICC, was people's belief in international organizations' ability to meet their missions, to dedicate their resources towards accomplishing their missions, to behaving in an impartial and fair way, not targeting any particular actors within the regime, etc. So I think then this is where complementarity comes into play, right? And with my colleague, Stephen Shadowin, an assistant professor of government at Harvard, we're exploring the effectiveness of complementarity as an argument for, as a legitimating claim that is communicated to publics. And so essentially complementarity, besides being a legal rule, we could think of it as procedural fairness. And so if you communicate to the public that the only reason we've gotten to this point is because year after year after year, 14 years of preliminary examination reports talking about, the progress that was made, the progress that was not made, and, the submissions that were sent to the countries in question that, hey, we're under preliminary examination. It's very important that you investigate. We see that your investigation has stalled, or we see that you're not actually going for those most responsible, et cetera, et cetera. And okay, now we're going to have to open up an investigation because the country has proven unwilling and or unable to conduct its own serious investigations, and where appropriate prosecutions and where appropriate convictions, verdicts, convictions, and sentences, et cetera. So we want to actually see if complementarity is persuasive as a frame. We did an initial experiment in the Republic of Georgia, which is also under consideration, the situation there from the 2008 conflict. And in that particular context, we did not find that knowledge of complementarity, so essentially giving people the rationale for the ICC's legal action in the country, spurs support for the court. So that's kind of interesting. We'd also done, some time analyses to see the use of complementarity in press statements and news releases by the Office of the Prosecutor. It's increased significantly over time. 1/3 of statements by the Office of the Prosecutor in 2019 touched on complementarity, either using the word itself or the principles. And so we see that, this has always been foundational to the court's exercise of jurisdiction, but the court is using this language more and more And at least in Georgia, at least with the experimental setup we had, working with a CRCC Georgia survey firm there, we didn't find that the result obtains. And so right now we are designing a replication to the US context, because if complementarity is not persuasive to publics, right? Yet that is, framing so much of the court's communications to folks at the UN, to countries under investigation, to potential court allies and compliance partners, then we might need a pivot. And this is where more general arguments about the court being effective, which again is not really available to us at the moment because of the few prosecutions that have resulted in convictions and sentences. So maybe impartiality. This is really an interesting time to be studying the court. And so we'll keep y'all apprised as we advance this set of experiments, as well as one other one on essentially forum shopping. So, okay, maybe you don't want the case to be handled at the ICC. What other venues? And so kind of like engaging positive complementarity. So let's see if you generally support war crimes prosecutions, but not in the international court, what is the venue that you prefer? And kind of having individuals rank systems by third-party states, their own country, etc.
Fantastic, thank you. So we're getting a little short on time. We're just in our last few minutes here. And I would like to give everyone an opportunity to make some last comments. I know, Adam, in relation to, there are a number of questions in relation to, the ability of the individuals and the court to sort of fight back against these sanctions in court. Beth, there were some questions about your proposal about licenses and how that might be used by the Trump administration. Liz, there are some questions about the reaction of the international community and how to be, supportive of them, some of the issues that we've talked about. And Katie, some questions about exactly how this affects your work. And I apologize, I think, we're not going to have we certainly won't have time to deal those all with justice. So you might have to just choose one thing to sort of make final comments in the 3 or 4 minutes we have left. So Liz, I'll turn it over to you.
Okay, thanks, Andrew. Well, conveniently enough, I can refer everyone to Beth's incredible compilation of all the responses to the executive order that she published on just security. That was before the designations at the beginning of this month. But I think it'll give everyone a good flavor of what we've seen, which has really been a tidal wave of opposition to the use of US sanctions authority in this way. And this real perversion of taking a tool that is at least intended to be used to disrupt the work of human rights violators and turning it against a court that is actually set up to bring accountability for the worst of those violations. I wanted to just point to a couple of reactions. One, again, just right before the executive order, the ICC member countries that belong to the UN Security Council issued a joint statement of support for the ICC. And this was before the executive order, but as the US was signaling that it was looking to take further action. It was a really strong and coherent sense of support from a body that has an important role to play in providing the ICC with the support it needs. And also a joint statement of 67 ICC states parties that was issued after the executive order, again, reaffirming their support for the court. And I mention those because sometimes the US government has mentioned that it would like to work with allies on a reform agenda for the court, that it somehow seems to suggest that it does have support among ICC member countries for this kind of attack on the court. And it becomes, because these countries are being invoked in that way, it becomes all the more important that they are clear in distinguishing that they respect this court as an independent institution, that they know it has a vital mandate. And as we go forward with discussions about how the court's delivery of justice can be strengthened, I think it's equally important that the eyes remain on the prize, which is a court that is effective, which is a court that can counter impunity wherever it's possible within its jurisdiction, and regardless of the nationality of those perpetrators, and really stands for that equal application of the law, and that we don't, because of all the challenges we've seen, step back from the goal, which was really what was animating many of us in civil society that supported the court's creation in the first place. So we want to see more of the same in terms of reactions that we've seen and sustained support for the legitimacy of the court, and to have the full goals of the court realized, and just to always keep in mind that we're here because of the impunity that has flourished in Afghanistan for the abuses that the prosecutor is seeking to investigate, and really never allow that to drift too far from our consciousness.
Katie, I'll turn to you next.
Sure, thank you. Just a couple of very quick points. You know, the US government makes the argument that the ICC impinges on its sovereignty. And I just want to drive home the point that the US did not have to go and commit egregious human rights violations, crimes on the territory of other countries. And when it did so knowing that they were members of the ICC. The US has had ample opportunity to investigate and prosecute its own. Instead, it has, as I said, blocked proceedings at the domestic level, blocked universal jurisdiction proceedings, and now is blocking the ICC. So it's a little rich to hear about sovereignty. Likewise, jury trials. The vast majority of criminal trials in the United States end in plea bargains, and so we don't always have these jury trials. Allies were mentioned. I think it's important to mention one other ally, because there is a reference in the executive order to sanctions and penalties also coming if certain other allied country investigations proceed. And as was made clear by statements from John Bolton in the lead up to the executive order, and then at the press conference when the executive order came out, Israel is the ally in question there. I represent victims in that situation as well. And in the larger picture, I think it is deeply concerning. And Adam, I definitely want to leave time for you. The slides that Adam showed, and the potential legal liability that could befall so many, from victims to lawyers to amici to investigators to private companies, to institutions. And we didn't even talk about the travel ban, the immigration ban part of the executive order. So this is deeply, deeply disturbing to my mind as an American lawyer. It's antithetical to the rule of law. So I do hope that we see a rescission of this frankly dangerous and hopefully not precedent setting for other other countries, this executive order.
Thank you so much, Katie. And Adam, I'm turning it over to you with negative time, so I apologize, but
no worries.
I'll give you the last word.
So, I mean, people have been asking, and the questions are, what next? What are the potential options here? Obviously, the executive could withdraw it, but obviously, which is not going to happen certainly before January, and then even after then, who knows? But there's obviously litigation challenges that are possible here. As Katie was saying, there are First Amendment challenges. There are potential challenges against AIPA itself, which I mentioned. I didn't mean to poo-poo. It's the challenge there is that there have been very few of them and very few successful ones, just because the deference is provided so great. There are challenges principally against U.S. persons who are theoretically providing support that could be in violation of the executive order. So there are First Amendment potential challenges, Fifth Amendment challenges, or otherwise. I mean, this is all possible. And in fact, what's interesting about AIPA, that rule I keep talking about, it's been used in everything, including a lot of the China sort of issues within the government. The reason that's relevant is that on Saturday night, a court in California issued an injunction against an AIPA-based executive order that was going to ban WeChat. You might think that's not related to this issue at all. It's incredibly related to this issue, because the same challenges were made to that executive order as could potentially made to this one. And the issue that the judge decided upon was principally First Amendment based. And so I think that there is an exemption under AIPA for various First Amendment activities. The question is whether or not those First Amendment activities include the support that would be provided to the court in all of these ways. So that issue is very much open. But I think that is the issue. Whether or not Bensouda and her deputy can challenge their designations, they can do that too. There's regulatory reconsideration and filing suit in court. The challenge there is, though, the issue of that is usually you got the wrong person. as opposed to the structure is illegal, right, or improper. Here, the issue is not you got the wrong person, you did get the right person, right? You got someone who was helping in this regard. The question is whether or not the executive order, the IEPA authorities extend to this level. And I think that is certainly an area of ripe for litigation that people are probably going to be pursuing.
Well, with that, thank you all again so much for participating in this conversation. We could go on for another 2 hours. It's a fascinating topic, and look forward to reading what you are writing on this.